Hi, it's Bernard Nomberg with Nomberg Law Firm, and one issue that we deal with quite frequently is mileage reimbursement in the workers' compensation arena. This is for injured workers whose claims have been approved. They're entitled, according to the Alabama Code, Alabama Administrative Code, that they're entitled to reimbursement for mileage for approved visits and for dropping off prescriptions and those kind of things. But I want to read to you a little bit directly out of the code because it can be a pretty tricky situation. Alabama Code section 25571F says, the employer shall pay mileage costs to and from medical and rehabilitation providers at the same rate as provided by law for official state travel. As of January 2018, that was about 54.5 cents per mile. It'll change each January. I'm not sure what January of 2019 will be, but it'll be within a couple of pennies of that. And there are a few other things to share with you about this because it does become confusing. Mileage is not reimbursed from work to normal residence, that type of drive. It is reimbursed at a reasonable rate from home to the approved doctor's visit or physical therapy visit, or one round trip to dropping off or picking up prescriptions, not both. When you first have a claim, the employer is supposed to notify you of your eligibility to be reimbursed within 2 weeks of accepting of the claim. And this is one of the key things because some employees don't turn this stuff in until the very end of the case. You have 1 year from the date of the incurred expense, meaning 1 year from the date you take that trip to the approved visit, to turn in that mileage, and then the employer has, or the insurance company has 30 days to pay it. Our rule of thumb is every 30 to 60 days, give us your list, and we've got a form that we use, we'll be glad to give it to you, that lists the date, the name of the location of where you're going, the total amount of mileage round trip, and then you make a form or a ledger out of it and add it all up. Now it's all subject to review, but I want to give you an example of one case that is of recent note that kind of defines a lot of this. It's Page versus Southern Care. It came out in 2016, Alabama law. This was a nurse who found temporary work. She lived in Alabama, but she found work in South Florida and South Georgia. And she submitted mileage for her visits from where she was temporarily living in those two out-of-state states as mileage. And as you can imagine, she lived in Northeast Alabama. The employment on a temporary basis was in South Florida and South Georgia. And this was also during a time when she was still getting workers' comp approved medical care. Well, she submitted thousands of miles, and the court ultimately ruled that the travel must be reasonably necessary. And it was undisputed that the employee could have gone to the doctor's back at home while she was home and off of work. So those types of mileage are not and were not approved. So reasonably necessary and fair costs are kind of the key, and every bit of it's a little bit different, but I'll be glad to go over it with you. We can explain it, but it has to be for approved medical care, and that's the key, meaning you can't go to your own doctors. If you have questions or concerns about this, just give us a call. We deal with this all the time. 205-930-6900 is our office number. NombergLaw.com. We can also be found on Facebook, YouTube, and Twitter.